as part of our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create the platform to hear your silent and unheard views in this hugely growing community in the United Kingdom, our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Thank you for being part of the program today. My name is Tunde Alabi, and the program is Voice. This is a program where we'll bring to you information concerning living and studying or doing business in the United Kingdom from the legal perspective. It's a legal program. It's our community educational program where we educate our community on the legal implication of their status, either as students or as business people, investors in the United Kingdom, or even if you're a resident in the United Kingdom, what are some of the provisions of the law regarding what we do as individuals in the United Kingdom. Welcome, and the program today is Voice. Taking a look at two important issues on the show today. First, couple of years ago or months ago, we spoke about the 7-year rule for anybody who has got children that are born in this country and or have been in this country for up to 7 years. There have been issues around the 7-year rules. Quite a number of people have said they have been denied based on the 7-year rule provision. Why would the government, under any circumstance, turn around to say the provision of the 7-year rule for children who have been in this country for that length of time would no longer be able to qualify them to have a stay in the country? And these issues and many more we'll be taking a look at on the program today. Voice, your legal educational program. My guest today is the principal partner at Obaseki Solicitors, Jennifer Obaseki. Join us on the show today to further review the provisions of the law as it affects or impacts on the 7-year rule immigration level. Jennifer, thank you for being part of the program today.
My pleasure.
A couple of months ago, probably over a year now, we spoke about the 7-year rule and how people can quickly catch in on that provision. Do you want to let us know, review that situation, how far it has come, how far it has gone from the experience of your clients?
Well, unfortunately, there has been the tightening of this rule. Before, there was a rule that allowed for people to make an application for their children to stay after 5 years, but the government repealed that many years ago and then brought in this new rule for children who had been born in the United Kingdom or spent over 7 years living here. The problem is the government realised that many people were just jumping on the bandwagon, and also realised that if these children were expected actually to leave the United Kingdom with their family, then they shouldn't automatically get the right to stay here. So there was a tightening up of how the rule was applied. So rather than people just having children that were here, then when they reach their 7th birthday, making an application and then be granted discretionary leave to remain, the government then basically, towards the end of last year, in our last programme, we outlined that they put down more or less the proviso that the family needed to prove why there would be barriers to that child reintegrating in the country of origin. So that sort of came about with the 2014 Immigration Act. And so you were finding that a lot of people were automatically just being refused, whereas initially they were applying and automatically being granted. So some people will be, to the point where they'll say, I was granted, but so how come you were not? And maybe one was first in time, the other one was second in time after the more stricter application of the rules. When we talk about these rules and how the government has redefined in the Immigration Act 2014 how it should be applied, outlining why your child will have barriers to reintegration. As we've explained in our previous program, you may need to have a social worker's report to outline this, an educational report from an educational psychologist, especially if your child is ill or has autism or has a learning difficulty. So if the child has learning disabilities or needs specific support, you really need to outline why there are not the provisions in your home country to support that child's learning, social integration or development. Even though in the first 7 years of a child's life, they are basically at those key stages of development in their character, their persona, their education. And again, if a child has emotional problems, even medical issues, they have to be outlined within the application that's made to the Home Office. So it's not as straightforward as just filling out the form showing that the child is in school and has never left the United Kingdom. That is not sufficient. Again, there have been judgments early this year that have basically reinforced the fact that it should not be automatic. So these judgments that have come down from the Supreme Court are saying that if a child is with their family and expected to return with their family, so the child does not have leave to remain in the United Kingdom, neither does the child's parent, even if the child has two parents, neither does either parent, then there is no reason why that child should still, stay in the United Kingdom. The child should be expected to go back to the country of origin with the parents who are here also illegally. The judgments accept that there'll be a period of adjustment. In other words, it's not going to be smooth sailing. The child will need to learn to adapt. But those adaptations that will be needed will be supported by the child's family and network. So you need to show why the child will not be able to adapt, what those barriers will be. If you're going to be destitute upon return, if the child is going to be targeted for any reason. So for example, if the child is a female child and you're going back to a region that is one that suffers the risk of FGM or even young marriage or trafficking, then you need to outline why that child will still be at risk if the child is returned back to the country of origin. So don't be disheartened if you are trying to, let's say you've made an application or you are thinking about making an application. The whole idea is to make sure that the correct evidence is there to support the application when it goes in, to show that there are real barriers to the child reintegrating into the country of origin, and show if there's any risk factors, what those risks are, and how they have to be outlined in a subjective fashion, not just general things, generally that the child won't like the food, or generally the country is unstable. It has to be very subjective. Why will your child have a specific risk and be, a risk of serious harm to some degree? Then at the same time, if you can show that there is such a serious level of harm, you may be invited by the Home Office to say, rather than you saying your child's human rights are going to be affected in that way, not in the way of the disruption of family life, not in the Article 8 way, but in the Article 3 way, which is saying that you'll be subject to harmful or degrading treatment. So if you're trying to say that, I'm at risk of serious harm, of degrading treatment, or harm to my life, which is Article 2, then the Home Office may say, rather than make this type of postal application under the 7-year rule, if you're asking for protection, then you should be claiming asylum. And this may apply to children who are disabled. So children who may be labelled, let's say, when you look at our culture, some parts of Nigeria, people do not have forward thinking and exclude disabled children from society. So if you are from a region where you know that if your child goes back as a disabled child or a child that has some form of disability, not necessarily just physical, whether it's mental, whether it's autism or something else, and you feel the child will be targeted, then you would need to show that subjectively. You would also need to show why the government would not have adequate provision to give you support or protection. And then you may decide to make an application for asylum. The reason why the government says this is that they say that Article 3 requests and asylum are so similar that rather than sit down and make those submissions on paper for Article 3, you should come and ask for international protection by making a claim for asylum at the Home Office. Again, don't be weary if you're asked to do that. You have to take advice and follow the steps that you've been advised to do by the Home Office in the letters. The most important thing is take advice. Don't simply fill out the forms or make submissions or change course of direction within your application without taking the advice, because there are criteria for these applications, and there's criteria even for claiming asylum. And it's important that you actually make sure that when you're making these representations on your behalf, you do them in the correct manner. You also don't take it lightly and forget to outline the fact that, exactly what the risks are. You must be able to outline exactly what the risks are. There's one issue of credibility. Whenever we get decisions that are refused, and when the refusals are down to is credibility, which is basically either the Home Office or the court saying we don't believe you. Most of the time it's because people haven't been consistent, and they haven't really been clear. They've made, let's say, a change in direction, or they've mentioned something late in the day rather than mentioning it right at the beginning. So it's usually down to delay or inconsistency. That's one of the reasons why it's quite important that you sit down with a professional to talk over your case before you make the application, so you're guided as to what's important. At times, pulling information from clients is quite difficult. Usually, talking about things that are distressing is going to be difficult anyway. Again, another reason why it's important to speak to a professional who will help you through the difficult time, gathering that difficult information, outlining to you what is important when making your applications.
Do you need legal advice? Do you need professional help at a reasonable cost? At Obaseki Solicitors, we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you. Book a free consultation today. Obaseki Solicitors, providing you with advice and assistance at all levels.
By implication, does it mean that trying to say, look, taking the advantage of the 7-year rule is not really an advantage? Or there could be some barriers.
There can be barriers
if it's not well planned,
yes,
and dealt with.
Correct. You see, one of the reasons why we've decided to do this topic again is because when you're making these applications, it's important that you make all of the necessary submissions at the beginning. Don't delay. Now there's a new judgment out about student finance.
Well, before we come to...
But the reason why I'm mentioning that is because unless you make all the necessary submissions at the time of the application, when it comes down to arguing your in-country right of appeal, or when it comes down to you arguing that the Home Office haven't looked in the proper manner or comprehensively at your case, you can't then start introducing new material. They'll tell you to go and make another application, because this is new things now you're now raising. These are new points you're now trying to raise in your application. You should try to raise everything succinctly at the beginning. If it's an issue of diet, if it's an issue of education, if it's an issue of physical well-being, you mention everything there and then. You don't mention just 2 of them and then later when you be refused say, oh, also you have to consider my physical well-being. If you haven't mentioned it all right at the beginning, outlined all the issues, you can't then start raising issues later. Also, if it's not expected that you return and it's not expected that you continue to make multiple applications, if you feel that it's going to be unreasonable for you to continue to make multiple applications for yourself or for your family or specifically for a child, then you also have to equally make those representations in your application. It's not a straightforward process. Knowing the technicalities for the subjective issues, and knowing the technicalities for the law and the new rules is another thing as well. So under the new rules, again, if you want to make representations to stay in the UK indefinitely, even though you don't qualify, but yet you feel there's a reason why you should be considered as a young person, you have to make those submissions in your application. Even if you haven't made a main application for settlement and you've made an application under, let's say, FLRO, but you want that caseworker at the Home Office who gets your form to consider that application for indefinite leave to remain, you have to make your submissions and you have to make it clear why. So, for example, I'm applying for a child who maybe has been in the UK for 8 years. They haven't been here consistently. Maybe they've had a brief break, but we're asking the Home Office to use discretion to look at that break. Maybe it was for 2 weeks. Maybe there was a dispute between the parents. One took the child home, another one got the child back, whether legally or illegally. But you're making submissions for this child because this child maybe needs to go to secondary school or is getting older, going from maybe 15 to 16, needs an NI number, now needs to be settled properly in the UK. When you're making that application, even though the child hasn't been here for over half their life, you may need to make submissions that that child intends to be here permanently. There's no longer a tussle between the parents. The child intends to stay here for the rest of their life, will be going to school, is fully settled, would have an emotional imbalance if removed. So when you're making that application, you would have to apply for that child to be here permanently. And when making those submissions, you have to be very clear that you would like that to be considered in the application. The reason why you do that is so that it's important that the caseworker has that as an option to look at. And if the child is not granted that, and even given just discretionary leave to remain, when that child goes on to university, that child can still argue for their right to have access to student finance. And again, that's why I bring it back to this issue of student finance. One of the things that the judges said when they were making the decision to say that it's illegal for the government to say people who have discretionary leave to remain or no recourse to public funds as a blanket should not be allowed to have access to student finance. The reason they said that is because they said it's disproportionate, that many of these children, it's not expected that they're going to go back home. So for them to just be refused access to funding to go to university is wrong, it's unfair, it's unreasonable. The young lady that brought the case, she was 16, she finished in school in Hackney and wanted to go to London School of Economics. She didn't realise that because she had discretionary leave to remain, she'd have to pay for her fees. And then when she did, she started this campaign because she lost her place, as many, many other young people have. And it's unfortunate, but the judgment has come into play. What we're advising people to do is to come and get advice, but basically you can Google the outcome of this case. And if you're going to university this year, try to attach it to your student loan and student finance applications if you have discretionary leave to remain, so that you try and argue your right to qualify. It's not automatic. You have to argue it, and you have to outline why within your immigration application it should have been understandable that you are not intending to return back to your country. To say that your sole reason is I want to go to university, they've said that's not good enough reason to access the student finance. You have to show that it's unreasonable to expect that you're going to be leaving, or if you have shown in your immigration application that it would be unreasonable for you to be making multiple applications to stay in the country. So how you word your representations when you're making your immigration application is so important. And also how you word your representations to the student finance company or for the NHS bursary, which we're also advising people to get advice on and try to challenge if you've been refused, if you're going in for nursing or a medical course. Very, very important. Try and get the judgment, try and get advice, and try and make your representations to increase the chance of you going to university and getting the funding to support your course.
Okay, all right. We are still talking about immigration, the rights of a child under the 7-year rule, which today we've been told is not basically automatic. However, that's not the end. Even if you've been refused trying to access that opportunity under the 7-year rule, you can still appeal. All you need to do is to justify the need why you think you're qualified to be granted your stay in this country under the 7-year rule. And of course, Jennifer did say something about accessing students' loan, that people who have initially been refused because either they've got no access to public funds or they have discretionary leave to remain. Now, a new judgment has come out that says, look, it is unfair to give that discrimination against people who have either limited leave to remain or have got no access to public funds. That's good news. That's very good news. Now people can go and pursue their academic career, even though they may not have indefinite leave to remain, even though they may not have access to public funds. That's good news coming from the court there on behalf of people, young people who are willing to study, progress their career. If you need more information, you can send Jennifer a text message on the phone number on the screen, or you can follow us on Twitter at Tunde C3, or better still, you can get advice from a qualified solicitor, but we advise that you get a qualified solicitor or give Jennifer a call. She might be able to support you in your application in any of these areas. Jennifer, let me quickly ask this question. We spoke about assessing students' loan for people who either have limited leave to remain in the UK or have got no access to public funds. Now, what about children who haven't got status yet but need to proceed to either college or university?
Okay, so for college, there's not usually a problem with the student finance issue. It's usually when they're going to university. Also depends on the course. As I've said, if it's a medically related course, nursing, mental health, then you may have to access the NHS bursary. So when it comes down to, let's say, secondary and college education, if the child is in social services care, social services may chip in and pay. If not, the local education authority normally covers the fees. But if it comes down to university, so that's from college and above, going into your degree type courses, then definitely it's the student finance company, or, as I say, the NHS if it's a medically related
would a student without status to be in the UK have would such a student child be able to progress to university?
The child must have a form of leave to remain. Previously, it was the case they said you had to have 3 years settled status, and when you looked at the definition of settled status, it was you must have indefinite leave to remain. That was in 2011. The rules changed, and that's when the prerequisites and the criteria was specified by the student finance company. But now this particular judgment outlines that is unreasonable. You use the word discrimination, and that was the exact word that the judge used. The judge outlined that it could be considered discriminatory under breach of Article 14 of the ECHR, plus just said it's completely disproportionate. So you must have a form of leave to remain. If you have discretionary leave to remain, you must try to argue your case with the funding provider, whether it's a student loan company or the NHS. We've been advising people to write appeal letters. There are templates for appeal letters that are there on the. You can try to Google them, or you can try and contact us. We'll get them in contact. Try and put you through to these templates so that you can use them. But the important thing is, you must try to fight your corner, fight for the funding, and then if you have, again, no recourse to public funds, you can try to apply for this to be removed, and we've given people the link for that form as well. Again, keep asking for these changes if you need them in order to survive. You must show that how adversely it's affecting your life.
Okay, absolutely. This is how far we can go with this program. Today we have looked at two important issues as student finance and the issue of the 7-year rule and the barriers around it on the program today. My name is Tunde Alabi, and we've been having a chat with the principal solicitor at Obaseki. So if you do need further advice on every issue we've discussed today, you can call or phone Jennifer on the number you have seen on your screen. You can follow us on Twitter at TundeC3. Thank you for being part of the program today. My name is Tunde Alabi. Until we come your way again, do stay out of trouble, and if you do get one, get a qualified solicitor. A very good week ahead of you. Bye. Economy, business, technology, the totality of what makes man is what we bring to you here on this sponge. We give you the information that you need, from business to economy to politics to technology, and that's all we do here on this sponge, from the beginning to the end, and that is why we are here. Keep watching this sponge from Ben Television.